This audio case is brought to you by Laudio. United States v. Morrison, Supreme Court of the United States. Decided May 15, 2000. Chief Justice Rehnquist delivered the opinion of the court. In these cases, we consider the constitutionality of 42 U.S.C. 13981, which provides a federal civil remedy for the victims of gender-motivated violence. The United States Court of Appeals for the Fourth Circuit, sitting en banc, struck down Section 13981 because it concluded that Congress lacked constitutional authority to enact the section's civil remedy. Believing that these cases are controlled by our decisions in United States v. Lopez, United States v. Harris, and the civil rights cases, we affirm. Petitioner Chrissy Brazancala enrolled at Virginia Polytechnic Institute, Virginia Tech, in the fall of 1994. In September of that year, Brazancala met respondents Antonio Morrison and James Crawford, who were both students at Virginia Tech and members of its varsity football team. Brazancala alleges that, within 30 minutes of meeting Morrison and Crawford, they assaulted and repeatedly raped her. After the attack, Morrison allegedly told Brazancala, "You better not have any diseases." In the months following the rape, Morrison also allegedly announced in the dormitory's dining room that he liked to get girls drunk and the omitted parts, quoted verbatim in the briefs on file with this court, consist of boasting, debased remarks about what Morrison would do to women, vulgar remarks that cannot fail to shock and offend. Brazancala alleges that this attack caused her to become severely emotionally disturbed and depressed. She sought assistance from a university psychiatrist who prescribed antidepressant medication. Shortly after the rape, Brazancala stopped attending classes and withdrew from the university. In early 1995, Brazancala filed a complaint against respondents under Virginia Tech's sexual assault policy. During the school-conducted hearing on her complaint, Morrison admitted having sexual contact with her despite the fact that she had twice told him no. After the hearing, Virginia Tech's Judicial Committee found insufficient evidence to punish Crawford, but found Morrison guilty of sexual assault and sentenced him to immediate suspension for 2 semesters. Virginia Tech's Dean of Students upheld the Judicial Committee's sentence. However, in July 1995, Virginia Tech informed Brazancala that Morrison intended to initiate a court challenge to his conviction under the sexual assault policy. University officials told her that a second hearing would be necessary to remedy the school's error in prosecuting her complaint under that policy, which had not been widely circulated to students. The university therefore conducted a second hearing under its abusive conduct policy, which was enforced prior to the dissemination of the sexual assault policy. Following the second hearing, the Judicial Committee again found Morrison guilty and sentenced him to an identical 2-semester suspension. This time, however, the description of Morrison's offense was, without explanation, changed from sexual assault to using abusive language. Morrison appealed his second conviction through the university's administrative system. On August 21, 1995, Virginia Tech's senior vice president and provost set aside Morrison's punishment. She concluded that it was excessive when compared with other cases where there has been a finding of violation of the abusive conduct policy. Virginia Tech did not inform Brazancala of this decision. After learning from a newspaper that Morrison would be returning to Virginia Tech for the fall 1995 semester, she dropped out of the university. In December 1995, Brazancala sued Morrison, Crawford, and Virginia Tech in the United States District Court for the Western District of Virginia. Her complaint alleged that Morrison's and Crawford's attack violated Section 13981 and that Virginia Tech's handling of her complaint violated Title IX of the Education Amendments of 1972. Morrison and Crawford moved to dismiss this complaint on the grounds that it failed to state a claim and that Section 13981 civil remedy is unconstitutional. The United States intervened to defend Section 13981's constitutionality. The District Court dismissed Rosencalla's Title IX claims against Virginia Tech for failure to state a claim upon which relief can be granted. It then held that Rosencalla's complaint stated a claim against Morrison and Crawford under Section 13981, but dismissed the complaint because it concluded that Congress lacked authority to enact the section under either the Commerce Clause or Section 5 of the 14th Amendment. A divided panel of the Court of Appeals reversed the District Court, reinstating Rosencalla's Section 13981 claim and her Title IX hostile environment claim. The full Court of Appeals vacated the panel's opinion and reheard the case en banc. The en banc court then issued an opinion affirming the District Court's conclusion that Rosencalla stated a claim under Section 13981 because her complaint alleged a crime of violence, and the allegations of Morrison's crude and derogatory statements regarding his treatment of women sufficiently indicated that his crime was motivated by gender animus. Nevertheless, the court, by divided vote, affirmed the District Court's conclusion that Congress lacked constitutional authority to enact Section 13981 civil remedy. Because the Court of Appeals invalidated a federal statute on constitutional grounds, we granted certiorari. Section 13981 was part of the Violence Against Women Act of 1994. It states that persons within the United States shall have the right to be free from crimes of violence motivated by gender. To enforce that right, subsection C declares, a person, including a person who acts under color of any statute, ordinance, regulation, custom, or usage of any state, who commits a crime of violence motivated by gender and thus deprives another of the right declared in the subsection B of this section, shall be liable to the party injured in an action for the recovery of compensatory and punitive damages, injunctive and declaratory relief, and such other relief as a court may deem appropriate. Section 13981 defines a crime of violence motivated by gender as a crime of violence committed because of gender or on the basis of gender, and due, at least in part, to an animus based on the victim's gender. It also provides that the term crime of violence includes any A. act or series of acts that would constitute a felony against the person, or that would constitute a felony against property if the conduct presents a serious risk of physical injury to another, and that would come within the meaning of state or federal offenses described in Section 16 of Title 18, whether or not those acts have actually resulted in criminal charges, prosecution, or conviction, and whether or not those acts were committed in the special maritime, territorial, or prison jurisdiction of the United States. And B. includes an act or series of acts that would constitute a felony described in subparagraph A, but for the relationship between the person who takes such action and the individual against whom such action is taken. Further clarifying the broad scope of Section 13981 civil remedy, subsection E2 states that nothing in this section requires a prior criminal complaint, prosecution, or conviction to establish the elements of a cause of action under subsection C of this section. And subsection E3 provides a Section 13981 litigant with a choice of forums. Federal and state courts shall have concurrent jurisdiction over complaints brought under this section. Although the foregoing language of Section 13981 covers a wide swath of criminal conduct, Congress placed some limitation on the section's federal civil remedy. Subsection E1 states that nothing in this section entitles a person to a cause of action under subsection C of this section for random acts of violence unrelated to gender or for acts that cannot be demonstrated by a preponderance of the evidence to be motivated by gender. Subsection E4 further states that Section 13981 shall not be construed to confer on the courts of the United States jurisdiction over any state law claim seeking the establishment of a divorce, alimony, equitable distribution of marital property, or child custody decree. Every law enacted by Congress must be based on one or more of its powers enumerated in the Constitution. The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten, the Constitution is written. Congress explicitly identified the sources of federal authority on which it relied in acting Section 13981. It said that a federal civil rights cause of action is established pursuant to the affirmative power of Congress under Section 5 of the 14th Amendment to the Constitution, as well as under Section 8 of Article 1 of the Constitution. We address Congress's authority to enact this remedy under each of these constitutional provisions in turn. Due respect for the decisions of a coordinate branch of government demands that we invalidate a congressional enactment only upon a plain showing that Congress has exceeded its constitutional bounds. With this presumption of constitutionality in mind, we turn to the question whether Section 13981 falls within Congress's power under Article 1, Section 8 of the Constitution. Morrison and the United States rely upon the third clause of the article, which gives Congress power to regulate commerce with foreign nations and among the several states and with the Indian tribes. As we discussed at length in Lopez, our interpretation of the Commerce Clause has changed as our nation has developed. We need not repeat that detailed review of the Commerce Clause's history here. It suffices to say that in the years since NLRB versus Jones and Laughlin Steel Corps, Congress has had considerably greater latitude in regulating conduct and transactions under the Commerce Clause than our previous case law permitted. Lopez emphasized, however, that even our modern expansive interpretation of the Commerce Clause, Congress's regulatory authority is not without effective bounds. Even our modern-era precedents, which have expanded congressional power under the Commerce Clause, confirm that this power is subject to outer limits. In Jones and Laughlin Steel, the court warned that the scope of the interstate commerce power must be considered in the light of our dual system of government and may not be extended so as to embrace effects upon interstate commerce so indirect and remote that to embrace them, in view of our complex society, would effectually obliterate the distinction between what is national and what is local, and create a completely centralized government. As we observed in Lopez, modern Commerce Clause jurisprudence has identified three broad categories of activity that Congress may regulate under its commerce power. Second, Congress is empowered to regulate and protect the instrumentalities of interstate commerce, or persons or things in interstate commerce, even though the threat may come only from intrastate activities. Finally, Congress's commerce authority includes the power to regulate those activities having a substantial relation to interstate commerce, i.e., those activities that substantially affect interstate commerce. Petitioners do not contend that these cases fall within either the first two of these categories of Commerce Clause regulation. They seek to sustain Section 13981 as a regulation of activity that substantially affects interstate commerce. Given Section 13981's focus on gender-motivated violence wherever it occurs, rather than violence directed at the instrumentalities of interstate commerce, interstate markets, or things or persons in interstate commerce, we agree that this is the proper inquiry. Since Lopez most recently canvassed and clarified our case law governing this third category of Commerce Clause regulation, it provides the proper framework for conducting the required analysis of Section 13981. In Lopez, we held that the Gun-Free School Zones Act of 1990, which made it a federal crime to knowingly possess a firearm in a school zone, exceeded Congress's authority under the Commerce Clause. Several significant considerations contributed to our decision. First, we observed that Section 922G was a criminal statute that, by its terms, has nothing to do with commerce or any sort of economic enterprise, however broadly one might define those terms. Reviewing our case law, we noted that we have upheld a wide variety of congressional acts regulating intrastate economic activity, where we have concluded that the activity substantially affected interstate commerce. Although we cited only a few examples, we stated that the pattern of analysis is clear. Where economic activity substantially affects interstate commerce, legislation regulating that activity will be sustained. Both petitioners and Justice Souter's dissent downplay the role that the economic nature of the regulated activity plays in our Commerce Clause analysis. But a fair reading of Lopez shows that the non-economic criminal nature of the conduct at issue was central to our decision in that case. Lopez's review of Commerce Clause case law demonstrates that in those cases where we have sustained federal regulation of intrastate activity based upon the activity's substantial effects on interstate commerce, the activity in question has been some sort of economic endeavor. The second consideration that we found important in analyzing Section 922G was that the statute contained no express jurisdictional element which might limit its reach to a discrete set of firearm possessions that additionally have an explicit connection with or effect on interstate commerce. Such a jurisdictional element may establish that the enactment is in pursuance of Congress's regulation of interstate commerce. Third, we noted that neither Section 922G nor its legislative history contains express congressional findings regarding the effects upon interstate commerce of gun possession in a school zone. While Congress normally is not required to make formal findings as to the substantial burdens that an activity has on interstate commerce, the existence of such findings may enable us to evaluate the legislative judgment that the activity in question substantially affects interstate commerce, even though no such substantial effect is visible to the naked eye. Finally, our decision in Lopez rested in part on the fact that the link between gun possession and a substantial effect on interstate commerce was attenuated. The United States argued that the possession of guns may lead to violent crime, and that violent crime can be expected to affect the functioning of the national economy in two ways. First, the costs of violent crime are substantial, and through the mechanism of insurance, those costs are spread throughout the population. Second, violent crime reduces the willingness of individuals to travel to areas within the country that are perceived to be unsafe. The government also argued that the presence of guns at schools poses a threat to the educational process, which in turn threatens to produce a less efficient and productive workforce, which will negatively affect national productivity and thus interstate commerce. We rejected these costs of crime and national productivity arguments because they would permit Congress to regulate not only all violent crime, but all activities that might lead to violent crime, regardless of how tenuously they relate to interstate commerce. We noted that under this but-for reasoning, Congress could regulate any activity that it found was related to the economic productivity of individual citizens. Family law, including marriage, divorce, and child custody, for example. Under these theories, it is difficult to perceive any limitation on federal power, even in areas such as criminal law enforcement or education, where states historically have been sovereign. Thus, if we were to accept the government's arguments, we are hard-pressed to posit any activity by an individual that Congress is without power to regulate. With these principles underlying our Commerce Clause jurisprudence as reference points, the proper resolution of the present cases is clear. Gender-motivated crimes of violence are not, in any sense of the phrase, economic activity. While we need not adopt a categorical rule against aggregating the effects of any non-economic activity in order to decide these cases, thus far in our nation's history, our cases have upheld Commerce Clause regulation of intrastate activity only where that activity is economic in nature. Like the Gun-Free School Zones Act at issue in Lopez, Section 13981 contains no jurisdictional element establishing that the federal cause of action is in pursuance of Congress's power to regulate interstate commerce. Although Lopez makes clear that such a jurisdictional element would lend support to the argument that Section 13981 is sufficiently tied to interstate commerce, Congress elected to cast Section 13981's remedy over a wider and more purely intrastate body of violent crime. In contrast with the lack of congressional findings that we face in Lopez, Section 13981 is supported by numerous findings regarding the serious impact that gender-motivated violence has on victims and their families. But the existence of congressional findings is not sufficient by itself to sustain the constitutionality of Commerce Clause legislation. As we stated in Lopez, simply because Congress may conclude that a particular activity substantially affects interstate commerce does not necessarily make it so. Rather, whether particular operations affect interstate commerce sufficiently to come under the constitutional power of Congress to regulate them is ultimately a judicial rather than a legislative question and can be settled finally only by this court. In these cases, Congress's findings are substantially weakened by the fact that they rely so heavily on a method of reasoning that we have already rejected as unworkable if we are to maintain the Constitution's enumeration of powers. Congress found that gender-motivated violence affects interstate commerce by deterring potential victims from traveling interstate, from engaging in employment in interstate business, and from transacting with business and in places involved in interstate commerce, by diminishing national productivity, increasing medical and other costs, and decreasing the supply of and the demand for interstate products. Given these findings and petitioners' arguments, the concern that we expressed in Lopez that Congress might use the Commerce Clause to completely obliterate the Constitution's distinction between national and local authority seems well-founded. The reasoning that petitioners advance seeks to follow the but-for causal chain from the initial occurrence of violent crime, the suppression of which has always been the prime object of the state's police power, to every attenuated effect upon interstate commerce. If accepted, petitioners' reasoning would allow Congress to regulate any crime as long as the nationwide aggregated impact of that crime has substantial effects on employment, production, transit, or consumption. Indeed, if Congress may regulate gender-motivated violence, it would be able to regulate murder or any other type of violence, since gender-motivated violence as a subset of all violent crime is certain to have lesser economic impacts than the larger class of which it is a part. Petitioners' reasoning, moreover, will not limit Congress to regulating violence, but may, as we suggested in Lopez, be applied equally as well to family law and other areas of traditional state regulation, since the aggregate effect of marriage, divorce, and child rearing on the national economy is undoubtedly significant. Congress may have recognized this specter when it expressly precluded Section 13981 from being used in the family law context. Under our written Constitution, however, the limitation of congressional authority is not solely a matter of legislative grace. We accordingly reject the argument that Congress may regulate non-economic, violent criminal conduct based solely on that conduct's aggregate effect on interstate commerce. The Constitution requires a distinction between what is truly national and what is truly local. In recognizing this fact, we preserve one of the few principles that has been consistent since the clause was adopted. The regulation and the punishment of intrastate violence that is not directed at the instrumentalities, channels, or goods involved in the interstate commerce has always been the province of the states. Indeed, we can think of no better example of the police power which the founders denied the national government and reposed in the states than the suppression of violent crime and vindication of its victims. Because we conclude that the Commerce Clause does not provide Congress with authority to enact Section 13981, we address petitioners' alternative argument that the section's civil remedy should be upheld as an exercise of Congress's remedial power under Section 5 of the 14th Amendment. As noted above, Congress expressly invoked the 14th Amendment as a source of authority to enact Section 13981. The principles governing an analysis of congressional legislation under Section 5 are well settled. Section 5 states that Congress may enforce by appropriate legislation the constitutional guarantee that no state shall deprive any person of life, liberty, or property without due process of law, nor deny any person equal protection of the laws. Section 5 is a positive grant of legislative power that includes authority to prohibit conduct which is not itself unconstitutional and to intrude into legislative spheres of autonomy previously reserved to the states. However, as broad as the congressional enforcement power is, it is not unlimited. In fact, as we discuss in detail below, several limitations inherent in Section 5's text and constitutional context have been recognized since the 14th Amendment was adopted. Petitioner's Section 5 argument is founded on an assertion that there is pervasive bias in various state justice systems against victims of gender-motivated violence. This assertion is supported by a voluminous congressional record. Specifically, Congress received evidence that many participants in state justice systems are perpetuating an array of erroneous stereotypes and assumptions. Congress concluded that these discriminatory stereotypes often result in insufficient investigation and prosecution of gender-motivated crime, inappropriate focus on the behavior and credibility of the victims of that crime, and unacceptably lenient punishments for those who are actually convicted of gender-motivated violence. Petitioners contend that this bias denies victims of gender-motivated violence the equal protection of the laws, and that Congress therefore acted appropriately in enacting a private civil remedy against the perpetrators of gender-motivated violence to both remedy the state's bias and deter future instances of discrimination in the state courts. As our cases have established, state-sponsored gender discrimination violates equal protection unless it serves important governmental objectives and the discriminatory means employed are substantially related to the achievement of those objectives. However, the language and purpose of the 14th Amendment place certain limitations on the manner in which Congress may attack discriminatory conduct. These limitations are necessary to prevent the 14th Amendment from obliterating the framers' carefully crafted balance of power between the states and the national government. Foremost among these limitations is the time-honored principle that the 14th Amendment, by its very terms, prohibits only state action. The principle has become firmly embedded in our constitutional law that the action inhibited by the first section of the 14th Amendment is only such action as may fairly be said to be that of the states. That amendment erects no shield against merely private conduct, however discriminatory or wrongful. Shortly after the 14th Amendment was adopted, we decided two cases interpreting the amendment's provisions. In Harris, the court considered a challenge to Section 2 of the Civil Rights Act of 1871. That section sought to punish private persons for conspiring to deprive anyone of the equal protection of the laws enacted by the state. We concluded that this law exceeded Congress's Section 5 power because the law was directed exclusively against the action of private persons without reference to the laws of the state or their administration by her officers. In so doing, we re-emphasize our statement from Virginia v. Rivas that these provisions of the 14th Amendment have reference to state action exclusively and not to any action of private individuals. We reached a similar conclusion in the civil rights cases. In those consolidated cases, we held that the public accommodation provisions of the Civil Rights Act of 1875, which applied to purely private conduct, were beyond the scope of the Section 5 enforcement power. The force of the doctrine of stare decisis behind these decisions stems not only from the length of time they have been on the books, but also from the insight attributable to the members of the court at that time. Every member had been appointed by President Lincoln, Grant, Hayes, Garfield, or Arthur, and each of their judicial appointees obviously had intimate knowledge and familiarity with the events surrounding the adoption of the 14th Amendment. Petitioners contend that two more recent cases have in effect overruled this long-standing limitation on Congress's Section 5 authority. They rely on United States v. Guest for the proposition that the rule laid down in the civil rights cases is no longer good law. In Guest, the court reversed the construction of an indictment under 18 U.S.C. Section 241, saying in the course of its opinion that we deal here with issues of statutory construction, not with issues of constitutional power. Three members of the court, in a separate opinion by Justice Brennan, expressed the view that the civil rights cases were wrongly decided and that Congress could, under Section 5, prohibit actions by private individuals. Three other members of the court, who joined the opinion of the court, joined a separate opinion by Justice Clark, which in 2 or 3 sentences stated the conclusion that Congress could punish all conspiracies with or without state action that interfere with 14th Amendment rights. Justice Harlan, in another separate opinion, commented with respect to the statement by these justices. The action of 3 of the justices who joined the court's opinion in nonetheless cursorily pronouncing themselves on the far-reaching constitutional questions deliberately not reached in Part 2 seems to me, to say the very least, extraordinary. Though these 3 justices saw fit to opine on matters not before the court in Guest, the court had no occasion to revisit the civil rights cases, and Harris, having determined the indictment charging private individuals with conspiring to deprive blacks of equal access to state facilities, in fact contained an express allegation of state involvement. The court concluded that the implicit allegation of active connivance by agents of the state eliminated any need to decide the threshold level that state action must attain in order to create rights under the Equal Protection Clause. All of this Justice Clark explicitly acknowledged. To accept petitioner's argument, moreover, one must add to the 3 justices joining Justice Brennan's reasoned explanation for his belief that the civil rights cases were wrongly decided. The 3 justices joining Justice Clark's opinion who gave no explanation whatever for their similar view. This is simply not the way that reasoned constitutional adjudication proceeds. We accordingly have no hesitation in saying that it would take more than the naked dicta contained in Justice Clark's opinion when added to Justice Brennan's opinion to cast any doubt upon the enduring vitality of the civil rights cases and Harris. Petitioners also rely on District of Columbia v. Carter. Carter was a case addressing the question whether the District of Columbia was a state within the meaning of Section 1979, 42 U.S.C. Section 1983, a section which by its terms requires state action before it may be employed. A footnote in that opinion recites the same litany respecting guests that petitioners rely on. This litany is of course entirely dicta, and in any event cannot rise above its source. We believe that the description of the Section 5 power contained in the civil rights cases is correct. But where a subject has not submitted to the general legislative power of Congress, but is only submitted thereto for the purpose of rendering effective some prohibition against particular state legislation or state action in reference to that subject, the power given is limited by its object. Any legislation by Congress in the matter must necessarily be corrective in its character, adapted to counteract and redress the operation of such prohibited state laws or proceedings of state officers. Petitioners alternatively argue that, unlike the situation in the civil rights cases, here there has been gender-based disparate treatment by state authorities, whereas in those cases there was no indication of such state action. There is abundant evidence, however, to show that the Congresses that enacted the Civil Rights Acts of 1871 and 1875 had a purpose similar to that of Congress in enacting Section 13981. There were state laws in the books bespeaking equality of treatment, but in the administration of these laws there is discrimination against newly freed slaves. The statement of Representative Garfield in the House and that of Senator Sumner in the Senate are representative. The chief complaint is not that the laws of the state are unequal, but that even where the laws are just and equal on their face, yet by a systematic maladministration of them, or a neglect or refusal to enforce their provisions, a portion of the people are denied equal protection under them. The legislature of South Carolina has passed a law giving precisely the rights contained in your supplementary civil rights bill, but such a law remains a dead letter on her statute books, because the state courts, comprised largely of those whom the senator wishes to obtain amnesty for, refuse to enforce it. But even if that distinction were valid, we do not believe it would save Section 13981's civil remedy. For the remedy is simply not corrective in its character, adapted to counteract and redress the operation of such prohibited state laws or proceedings of state officers, or as we have phrased it in more recent cases, prophylactic legislation under Section 5 must have a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. Section 13981 is not aimed at prescribing discrimination by officials which the 14th Amendment might not itself prescribe. It is directed not at any state or state actor, but at individuals who have committed criminal acts motivated by gender violence. In the present cases, for example, Section 13981 visits no consequence whatever on any Virginia public official involved in investigating or prosecuting Rosancala's assault. The section is therefore unlike any of the Section 5 remedies that we have previously upheld. For example, in Katzenbach v. Morgan, Congress prohibited New York from imposing literacy tests as a prerequisite for voting because it found that such requirement disenfranchised thousands of Puerto Rican immigrants who had been educated in the Spanish language of their home territory. That law, which was upheld, was directed at New York officials who administered the state's election law and prohibited them from using a provision of that law. In South Carolina v. Katzenbach, Congress imposed voting rights requirements on states that Congress found had a history of discriminating against blacks in voting. The remedy was also directed at state officials in those states. Similarly, in Ex parte Virginia, Congress criminally punished state officials who intentionally discriminated in jury selection. Again, the remedy was directed to the culpable state official. Section 13981 is also different from these previously upheld remedies in that it applies uniformly throughout the nation. Congress's findings indicate that the problem of discrimination against the victims of gender-motivated crimes does not exist in all states, or even most states. By contrast, the Section 5 remedy upheld in Katzenbach v. Morgan was directed only to the state where the evil found by Congress existed, and in South Carolina v. Katzenbach, the remedy was directed only to those states in which Congress found that there had been discrimination. For these reasons, we conclude that Congress's power under Section 5 does not extend to the enactment of Section 13981. Petitioner Rosancala's complaint alleges that she was the victim of a brutal assault. But Congress's effort in Section 13981 to provide a federal civil remedy can be sustained neither under the Commerce Clause nor under Section 5 of the 14th Amendment. If the allegations here are true, no civilized system of justice could fail to provide a remedy for the conduct of Respondent Morrison. But under our federal system, that remedy must be provided by the Commonwealth of Virginia and not by the United States. The judgment of the Court of Appeals is affirmed. Concurrence by Thomas. Justice Thomas concurring. The majority opinion correctly applies our decision in United States v. Lopez, and I join it in full. I write separately only to express my view that the very notion of a substantial effects test under the Commerce Clause is inconsistent with the original understanding of Congress's powers and with this court's early Commerce Clause cases. By continuing to apply this rootless and malleable standard, however circumscribed, the court has encouraged the federal government to persist in its view that the Commerce Clause has virtually no limits. Until this court replaces its existing Commerce Clause jurisprudence with a standard more consistent with the original understanding, we will continue to see Congress appropriating state police powers under the guise of regulating commerce. Justice Souter, with whom Justice Stevens, Justice Ginsburg, and Justice Breyer join, dissenting. The court says both that it leaves Commerce Clause precedent undisturbed and that the civil rights remedy of the Violence Against Women Act of 1994, 42 U.S.C. Section 13981, exceeds Congress's power under that clause. I find the claims irreconcilable and respectfully dissent. Our cases, which remain at least nominally undisturbed, stand for the following propositions. Congress has the power to legislate with regard to activity that, in the aggregate, has a substantial effect on interstate commerce. The fact of such a substantial effect is not an issue for the courts in the first instance, but for the Congress, whose institutional capacity for gathering evidence and taking testimony far exceeds ours. By passing legislation, Congress indicates its conclusion, whether explicitly or not, that facts support its exercise of the commerce power. The business of the courts is to review the congressional assessment, not for soundness, but simply for the rationality of concluding that a jurisdictional basis exists in fact. Any explicit findings that Congress chooses to make, though not dispositive of the question of rationality, may advance judicial review by identifying factual authority on which Congress relied. Applying those propositions in these cases can lead to only one conclusion. One obvious difference from United States v. Lopez is the mountain of data assembled by Congress, here showing the effects of violence against women on interstate commerce. Passage of the Act in 1994 was preceded by 4 years of hearings, which included testimony from physicians and law professors, from survivors of rape and domestic violence, and from representatives of state law enforcement and private business. The record includes reports on gender bias from task force in 21 states, and we have the benefit of specific factual findings in the 8 separate reports issued by Congress and its committees over the long course leading to enactment. With respect to domestic violence, Congress received evidence for the following findings. 3 out of 4 American women will be victims of violent crimes sometime during their life. Violence is the leading cause of injuries to women ages 15 to 44. As many as 50% of homeless women and children are fleeing domestic violence. Since 1974, the assault rate against women has outstripped the rate for men by at least twice for some age groups and far more for others. Battering is the single largest cause of injury to women in the United States. An estimated 4 million American women are battered each year by their husbands or partners. Over 1 million women in the United States seek medical assistance each year for injuries sustained from their husbands or other partners. Between 2,000 and 4,000 women die every year from domestic abuse. Arrest rates may be as low as 1 for every 100 domestic assaults. Partial estimates show that violent crime against women costs this country at least $3 billion, not million, but billion dollars a year. Estimates suggest that we spend $5 to $10 billion a year on healthcare, criminal justice, and other social costs of domestic violence. The evidence as to rape was similarly extensive, supporting these conclusions. The incidence of rape rose 4 times as fast as the total national crime rate over the past 10 years. According to one study, close to 500,000 girls now in high school will be raped before they graduate. 125,000 college women can expect to be raped during this or any year. 3/4 of women never go to the movies alone after dark because of the fear of rape, and nearly 50% do not use public transit alone after dark for the same reason. 41% of judges surveyed believed that juries give sexual assault victims less credibility than other crime victims. Less than 1% of all rape victims have collected damages. An individual who commits rape has only about 4 chances in 100 of being arrested, prosecuted, and found guilty of any offense. Almost 1/4 of convicted rapists never go to prison, and another quarter receive sentences in local jails, where the average sentence is 11 months. Almost 50% of rape victims lose their jobs or are forced to quit because of the crime's severity. Based on the data thus partially summarized, Congress found that crimes of violence motivated by gender have a substantial adverse effect on interstate commerce by deterring potential victims from traveling interstate, from engaging in employment in interstate business, and from transacting with business and in places involved in interstate commerce, by diminishing national productivity, increasing medical and other costs, and decreasing the supply of and the demand for interstate products. Congress thereby explicitly stated the predicate for the exercise of its Commerce Clause power. Is this conclusion irrational in view of the data amassed? True, the methodology of particular studies may be challenged, and some of the figures arrived at may be disputed. But the sufficiency of the evidence before Congress to provide a rational basis for the finding cannot seriously be questioned. Indeed, the legislative record here is far more voluminous than the record compiled by Congress and found sufficient in 2 prior cases upholding Title II of the Civil Rights Act of 1964 against Commerce Clause challenges. In Heart of Atlanta Motel, Inc. versus United States and Katzenbach v. McClung, the court referred to evidence showing the consequences of racial discrimination by motels and restaurants on interstate commerce. Congress had relied on compelling anecdotal reports that individual instances of segregation cost thousands to millions of dollars. Congress also had evidence that the average black family spent substantially less than the average white family in the same income range on public accommodations, and that discrimination accounted for much of the difference. While Congress did not, to my knowledge, calculate aggregate dollar values for the nationwide effects of racial discrimination in 1964, in 1994 it did rely on evidence of the harms caused by domestic violence and sexual assault, citing annual costs of $3 billion in 1990. Equally important, though, gender-based violence in the 1990s was shown to operate in a manner similar to racial discrimination in the 1960s, in reducing the mobility of employees and the production and consumption of goods shipped in interstate commerce. Like racial discrimination, gender-based violence bars as most likely targets women from full participation in the national economy. If the analogy to the Civil Rights Act of 1964 is not plain enough, one can always look back a bit further. In Wickard, we upheld the application of the Agricultural Adjustment Act to the planting and consumption of homegrown wheat. The effect on interstate commerce in that case followed from the possibility that wheat grown at home for personal consumption could either be drawn into the market by rising prices or relieve its grower of any need to purchase wheat in the market. The Commerce Clause predicate was simply the effect of the production of wheat for home consumption on supply and demand in interstate commerce. Supply and demand for goods in interstate commerce will also be affected by the deaths of 2,000 to 4,000 women annually at the hands of domestic abusers, and by the reduction in the workforce by the 100,000 or more rape victims who lose their jobs each year or are forced to quit. Violence against women may be found to affect interstate commerce and affect it substantially. The act would have passed muster at any time between Wickard in 1942 and Lopez in 1995, a period in which the law enjoyed a stable understanding that congressional power under the Commerce Clause, complemented by the authority of the Necessary and Proper Clause, Article 1, Section 8, Clause 18, extended to all activity that, when aggregated, has a substantial effect on interstate commerce. As already noted, this understanding was secure even against the turmoil at the passage of the Civil Rights Act of 1964, in the aftermath of which the court not only reaffirmed the cumulative effects and rational basis features of the substantial effects test, but declined to limit the commerce power through a formal distinction between legislation focused on commerce and statutes addressing moral and social wrongs. The fact that the act does not pass muster before the court today is therefore proof, to a degree, that Lopez was not, that the court's nominal adherence to the substantial effects test is merely that. Although a new jurisprudence has not emerged with any distinctness, it is clear that some congressional conclusions about obviously substantial cumulative effects on commerce are being assigned lesser values than the one stable doctrine would assign them. These devaluations are accomplished not by any express repudiation of the substantial effects test or its application through the aggregation of individual conduct, but by supplanting rational basis scrutiny with a new criterion of review. Thus, the elusive heart of the majority's analysis in these cases is its statement that Congress's findings of fact are weakened by the presence of a disfavored method of reasoning. This seems to suggest that the substantial effects analysis is not a factual inquiry for Congress in the first instance, with subsequent judicial review looking only to the rationality of the congressional conclusion, but one of a rather different sort, dependent upon a uniquely judicial competence. This new characterization of substantial effects has no support in our cases, the self-fulfilling prophecies of Lopez aside, least of all those the majority cites. Perhaps this explains why the majority is not content to rest on its cited precedent, but claims a textual justification for moving toward its new system of congressional deference subject to selective discounts. Thus, it purports to rely on the sensible and traditional understanding that the listing in the Constitution of some powers implies the exclusion of others unmentioned. The majority stresses that Article 1, Section 8 enumerates the powers of Congress, including the commerce power, an enumeration implying the exclusion of powers not enumerated. It follows for the majority not only that there must be some limits to commerce, but that some particular subjects, arguably within the commerce power, can be identified in advance as excluded on the basis of characteristics other than their commercial effects. Such exclusions come into sight when the activity regulated is not itself commercial or when the states have traditionally addressed it in the exercise of the general police power, conferred upon the state constitutions but never extended to Congress under the Constitution of the nation. The premise that the enumeration of powers implies that other powers are withheld is sound. The conclusion that some particular categories of subject matter are therefore presumptively beyond the reach of the commerce power is, however, a non sequitur. From the fact that Article 1, Section 8, Clause 3 grants an authority limited to regulating commerce, it follows only that Congress may claim no authority under that section to address any subject that does not affect commerce. It does not at all follow that an activity affecting commerce nonetheless falls outside the commerce power, depending on the specific character of the activity or the authority of a state to regulate it along with Congress. My disagreement with the majority is not, however, confined to logic, for history has shown that categorical exclusions have proven as unworkable in practice as they are unsupportable in theory. Obviously, it would not be inconsistent with the text of the Commerce Clause itself to declare non-commercial primary activity beyond or presumptively beyond the scope of the commerce power. That variant of categorical approach is not, however, the sole textually permissible way of defining the scope of the Commerce Clause, and any such neat limitation would at least be suspect in the light of the final sentence of Article 1, Section 8, authorizing Congress to make all laws necessary and proper to give effect to its enumerated powers such as commerce. Accordingly, for significant periods of our history, the Court has defined the commerce power as plenary, unsusceptible to categorical exclusions, and this was the view expressed throughout the latter part of the 20th century in the substantial effects test. These two conceptions of the commerce power, plenary and categorically limited, are in fact old rivals, and today's revival of their competition summons up familiar history, a brief reprise of which may be helpful in posing what I take to be the key question going to the legitimacy of the majority's decision to breathe new life into the approach of a categorical limitation. Chief Justice Marshall's seminal opinion in Gibbons v. Ogden construed the commerce power from the start with a breadth never yet exceeded. In particular, it is worth noting, the court in Wickard did not regard its holding as exceeding the scope of Chief Justice Marshall's view of interstate commerce. Wickard applied an aggregate effects test to ostensibly domestic, non-commercial farming, consistently with Chief Justice Marshall's indication that the commerce power may be understood by its exclusion of subjects, among others, which do not affect other states. This plenary view of the power has either prevailed or been acknowledged by this court at every stage of our jurisprudence. And it was this understanding, free of categorical qualifications, that prevailed in the period after 1937 through Lopez, as summed up by Justice Harlan. Of course, the mere fact that Congress has said when particular activity shall be deemed to affect commerce does not preclude further examination by this court. But where we find that the legislators have a rational basis for finding a chosen regulatory scheme necessary to the protection of commerce, our investigation is at an end. Justice Harlan spoke with the benefit of hindsight, for he had seen the result of rejecting the plenary view, and today's attempt to distinguish between primary activities affecting commerce in terms of the relatively commercial or non-commercial character of the primary conduct prescribed comes with the pedigree of near tragedy that I outlined in United States v. Lopez dissenting opinion. In the half-century following the modern activation of the commerce power with passage of the Interstate Commerce Act in 1887, this court, from time to time, created categorical enclaves beyond congressional reach by declaring such activities as mining, production, manufacturing, and union membership to be outside the definition of commerce, and by limiting application of the effects test to direct rather than indirect commercial consequences. Since adherence to these formalistically contrived confines of commerce power in large measure provoked the judicial crisis of 1937, one might reasonably have doubted that members of this court would ever again toy with a return to the days before NLRB versus Jones and Laughlin Steel Corps, which brought the earlier and nearly disastrous experiment to an end, and yet today's decision can only be seen as a step toward recapturing the prior mistakes. Its revival of a distinction between commercial and non-commercial conduct is at odds with Wickard, which repudiated that analysis, and the inquiry into commercial purpose, first intimated by the Lopez concurrence, is cousin to the intent-based analysis employed in Hammer, but rejected for Commerce Clause purposes in Heart of Atlanta and Darby. Why is the majority tempted to reject the lesson so painfully learned in 1937? An answer emerges from contrasting Wickard with one of the predecessor cases it superseded. It was obvious in Wickard that growing wheat for consumption right on the farm was not commerce in the common vocabulary, but that did not matter constitutionally so long as the aggregated activity of domestic wheat growing affected commerce substantially. Just a few years before Wickard, however, it had certainly been no less obvious that mining practices could substantially affect commerce, even though Carter Coal Company had held mining regulation beyond the national commerce power. When we try to fathom the difference between the two cases, it is clear that they did not go in different directions because the Carter Coal Court could not understand a causal connection that the Wickard Court could grasp. The difference, rather, turned on the fact that the court in Carter Coal had a reason for trying to maintain its categorical, formalistic distinction, while that reason had been abandoned by the time Wickard was decided. The reason was laissez-faire economics, the point of which was to keep government interference to a minimum. The court in Carter Coal was still trying to create a laissez-faire world out of the 20th century economy, and formalistic commercial distinctions were thought to be useful instruments in achieving that object. The court in Wickard knew it could not do any such thing, and in the aftermath of the New Deal had long since stopped attempting the impossible. Without the animating economic theory, there was no point in contriving formalisms in a war with Chief Justice Marshall's conception of the commerce power. If we now ask why the formalistic economic-non-economic distinction might matter today, after its rejection in Wickard, the answer is not that the majority fails to see causal connections in an integrated economic world. The answer is that in the minds of the majority, there is a new animating theory that makes categorical formalism seem useful again. Just as the old formalism had value in the service of an economic conception, the new one is useful in serving a conception of federalism. It is the instrument by which assertions of national power are to be limited in favor of preserving a supposedly discernible proper sphere of state autonomy to legislate or refrain from legislating as the individual states see fit. The legitimacy of the court's current emphasis on the non-commercial nature of regulated activity, then, does not turn on any logic serving the text of the Commerce Clause or on the realism of the majority's view of the national economy. The essential issue is rather the strength of the majority's claim to have a constitutional warrant for its current conception of a federal relationship enforceable by this court through limits on otherwise plenary commerce power. This conception is the subject of the majority's second categorical discount applied today to the facts bearing on the substantial effects test. The court finds it relevant that the statute addresses conduct traditionally subject to state prohibition under domestic criminal law, a fact said to have some heightened significance when the violent conduct in question is not itself aimed directly at interstate commerce or its instrumentalities. Again, history seems to be recycling, for the theory of traditional state concern as grounding a limiting principle has been rejected previously and more than once. It was disapproved in Darby and held insufficient standing alone to limit the commerce power in Hodel. In the particular context of the Fair Labor Standards Act, it was rejected in Maryland v. Wirtz, with the recognition that there is no general doctrine implied in the federal constitution that the two governments, national and state, are each to exercise its power so as not to interfere with the free and full exercise of the powers of the other. The court held it to be clear that the federal government, when acting within delegated power, may override countervailing state interests, whether these be described as governmental or proprietary in character. While Wirtz was later overruled by National League of Cities versus Usury, that case was itself repudiated in Garcia v. San Antonio Metropolitan Transit Authority, which held that the concept of traditional governmental function as an element of the immunity doctrine under Hodel was incoherent, there being no explanation that would make sense of the multifarious decisions placing some functions on one side of the line, some on the other. The effort to carve out inviolable state spheres within the spectrum of activities substantially affecting commerce was, of course, just as irreconcilable with Gibbon's explanation of the national commerce power as being as absolute as it would be in a single government. The objection to reviving traditional state spheres of action as a consideration in commerce analysis, however, not only rests on the portent of incoherence, but is compounded by a further defect just as fundamental. The defect, in essence, is the majority's rejection of the founders' considered judgment that politics, not judicial review, should mediate between state and national interests, as the strength and legislative jurisdiction of the national government inevitably increased through the expected growth of the national economy. Whereas today's majority takes a leaf from the book of the old judicial economists in saying that the court should somehow draw the line to keep the federal relationship in a proper balance, Madison, Wilson, and Marshall understood the Constitution very differently. Although Madison had emphasized the conception of a national government of discrete powers, a conception that a number of the ratifying conventions thought was too indeterminate to protect civil liberties, Madison himself must have sensed the potential scope of some of the powers granted, such as the authority to regulate commerce, for he took care in the Federalist No. 46 to hedge his argument for limited power by explaining the importance of national politics in protecting the state's interests. The national government will partake sufficiently of the spirit of the states to be disinclined to invade the rights of the individual states or the prerogatives of their governments. James Wilson likewise noted that it was a favorite object in the convention to secure the sovereignty of the states, and that it had been achieved through the structure of the federal government. The framers of the Bill of Rights, in turn, may well have sensed that Madison and Wilson were right about politics as the determinant of the federal balance within the broad limits of a power like commerce, for they formulated the 10th Amendment without any provision comparable to the specific guarantees proposed for individual liberties. In any case, this court recognized the political component of federalism in the seminal Gibbons opinion. After declaring the plenary character of congressional power within the sphere of activity affecting commerce, the Chief Justice spoke for the court in explaining that there is only one restraint on its valid exercise: the wisdom and the discretion of Congress, their identity with the people, and the influence which their constituents possess at elections are, in this, as in many other instances, as that, for example, of declaring war, the sole restraints on which they have relied, to secure them from its abuse. They are the restraints on which the people must often rely solely in all representative governments. Politics as the moderator of the congressional employment of the commerce power was the theme many years later in Wickard, for after the court acknowledged the breadth of the Gibbons formulation, it invoked Chief Justice Marshall yet again in adding that he made emphatic the embracing and penetrating nature of this power by warning that effective restraints on its exercise must proceed from political rather than judicial processes. Hence, conflicts of economic interest are wisely left under our system to resolution by Congress under its more flexible and responsible legislative process. Such conflicts rarely lend themselves to judicial determination, and with the wisdom, workability, or fairness of the plan of regulation, we have nothing to do. As with conflicts of economic interest, so with supposed conflicts of sovereign political interests implicated by the Commerce Clause, the Constitution remits them to politics. The point can be put no more clearly than the court put it the last time it repudiated the notion that some state activities categorically defy the commerce power as understood in accordance with generally accepted concepts. After confirming Madison's and Wilson's views with a recitation of the sources of state influence in the structure of the national Constitution, the court disposed of the possibility of identifying principled constitutional limitations on the scope of Congress's Commerce Clause powers over the states merely by relying on a priori definitions of state sovereignty. It concluded that the framers chose to rely on a federal system in which special restraints on federal power over the states inhered principally in the workings of the national government itself, rather than in discrete limitations on the objects of federal authority. State sovereign interests, then, are more properly protected by procedural safeguards inherent in the structure of the federal system than by judicially created limitations on federal power. The Garcia Court's rejection of judicially created limitations in favor of the intended reliance on national politics was all the more powerful owing to the court's explicit recognition that in the century since the framing, the relative powers of the two sovereign systems have markedly changed. Nationwide, economic integration is the norm. The national political power has been augmented by its vast revenues, and the power of the states has been drawn down by the 17th Amendment, eliminating selection of senators by state legislature in favor of direct election. The Garcia majority recognized that economic growth and the burgeoning of federal revenue have not amended the Constitution, which contains no circuit breaker to preclude the political consequences of these developments, nor is there any justification for attempts to nullify the natural political impact of the particular amendment that was adopted. The significance for state political power of ending state legislative selection of senators was no secret in 1913, and the amendment was approved despite public comment on that very issue. Representative Franklin Bartlett, after quoting Madison's Federalist No. 62, as well as remarks by George Mason and John Dickinson during the Constitutional Convention, concluded, "It follows, therefore, that the framers of the Constitution, were they present in this House today, would inevitably regard this resolution as a most direct blow at the doctrine of states' rights, and at the integrity of the state sovereignties. For if you once deprive a state as a collective organism of all share in the general government, you annihilate its federative importance. Massachusetts Senator George Hoare likewise defended indirect election of the Senate as a great security for the rights of the states, and Elihu Root warned that if the selection of senators should be taken from state legislatures, the tide that now sets toward the federal government will swell in volume and power. The time will come, he continued, when the government of the United States will be driven to the exercise of more arbitrary and unconsidered power, will be driven to greater concentration, will be driven to extend its functions into the internal affairs of the states. These warnings did not kill the proposal. The amendment was ratified, and today it is only the ratification, not the predictions, which this court can legitimately heed. Amendments that altered the balance of power between the national and state governments, like the 14th, or that changed the way the states are represented within the federal government, like the 17th, are not rips in the fabric of the framers' constitution inviting judicial repairs. The 17th Amendment may indeed have lessened the enthusiasm of the Senate to represent the states as discrete sovereignties, but the amendment did not convert the judiciary into an alternate shield against the commerce power. The court's choice to invoke considerations of traditional state regulations in these cases is especially odd in light of a distinction recognized in the now repudiated opinion for the court in usury. In explaining that there is no inconsistency between declaring the states immune to the commerce power exercised in the Fair Labor Standards Act, but subjected under the Economic Stabilization Act of 1970, as described in Frye v. United States, the court spoke of the latter statute as dealing with a serious threat affecting all the political components of the federal system, which only collective action by the national government might forestall. Today's majority, however, finds no significance whatever in the state's support for the act, based upon the state's acknowledged failure to deal adequately with gender-based violence in state courts, and the belief of their own law enforcement agencies that national action is essential. The National Association of Attorneys General supported the act unanimously, and attorneys general from 38 states urged Congress to enact the civil rights remedy, representing that the current system for dealing with violence against women is inadequate. It was against this record of failure at the state level that the act was passed to provide the choice of a federal forum in place of the state court systems found inadequate to stop gender-biased violence. The act accordingly offers a federal civil rights remedy aimed exactly at violence against women as an alternative to the generic state tort causes of action found to be poor tools of action by the state task forces. As the 1993 Senate report put it, the Violence Against Women Act is intended to respond both to the underlying attitude that this violence is somehow less serious than other crime and to the resulting failure of our criminal justice system to address such violence. Its goals are both symbolic and practical. The collective opinion of state officials that the act was needed continues virtually unchanged, and when the civil rights remedy was challenged in court, the states came to its defense. 36 of them and the Commonwealth of Puerto Rico have filed an amicus brief in support of petitioners in these cases, and only one state has taken respondent's side. It is then not the least irony of these cases that the states will be forced to enjoy the new federalism whether they want it or not. For with the court's decision today, Antonio Morrison, like Carter Cole's James Carter before him, has won the states' rights plea against the states themselves. All of this convinces me that today's ebb of the commerce power rests on error, and at the same time leads me to doubt that the majority's view will prove to be enduring law. There is yet one more reason for doubt. Although we sense the presence of Carter Cole, Schechter, and usury once again, the majority embraces them only at arm's length. Where such decisions once stood for rules, today's opinion points to considerations by which substantial effects are discounted. Cases standing for the sufficiency of substantial effects are not overruled. Cases overruled since 1937 are not quite revived. The court's thinking betokens less clearly a return to the conceptual straitjackets of Schechter and Carter-Cole and usury than to something like the unsteady state of obscenity law between Redrup v. New York and Miller v. California, a period in which the failure to provide a workable definition left this court to review each case ad hoc. As our predecessors learned then, the practice of such ad hoc review cannot preserve the distinction between the judicial and the legislative, and this court, in any event, lacks the institutional capacity to maintain such a regime for very long. This one will end when the majority realizes that the conception of the commerce power, for which it entertains hopes, would inevitably fail the test expressed in Justice Holmes' statement that the first call of a theory of law is that it should fit the facts. The facts that cannot be ignored today are the facts of integrated national commerce and a political relationship between states and nation, much affected by their respective treasuries and constitutional modifications adopted by the people. The federalism of some earlier time is no more adequate to account for those facts today than the theory of laissez-faire was able to govern the national economy 70 years ago. Justice Breyer, with whom Justice Stevens joins, and with whom Justice Souter and Justice Ginsburg join as to Part 1A dissenting. No one denies the importance of the Constitution's federalist principles. Its state-federal division of authority protects liberty, both by restricting the burdens that government can impose from a distance and by facilitating citizen participation in government that is closer to home. The question is how the judiciary can best implement that original Federalist understanding where the Commerce Clause is at issue. The majority holds that the federal commerce power does not extend to such non-economic activities as non-economic violent criminal conduct that significantly affects interstate commerce only if we aggregate the interstate effects of individual instances. Justice Souter explains why history, precedent, and legal logic militate against the majority's approach. I agree and join his opinion. I add that the majority's holding illustrates the difficulty of finding a workable judicial Commerce Clause touchstone, a set of comprehensible interpretive rules that courts might use to impose some meaningful limit, but not too great a limit, upon the scope of the legislative authority that the Commerce Clause delegates to Congress. Consider the problems. The economic, non-economic distinction is not easy to apply. Does the local street corner mugger engage in economic activity or non-economic activity when he mugs for money? Would evidence that desire for economic domination underlies many brutal crimes against women save the present statute? The line becomes yet harder to draw given the need for exceptions. The court itself would permit Congress to aggregate, hence regulate, non-economic activity taking place at economic establishments. And it would permit Congress to regulate where that regulation is an essential part of a larger regulation of economic activity in which the regulatory scheme could be undercut unless the intrastate activity were regulated. Given the former exception, can Congress simply rewrite the present law and limit its application to restaurants, hotels, perhaps universities, and other places of public accommodation? Given the latter exception, can Congress save the present law by including it or much of it in a broader Safe Transport or Workplace Safety Act? More importantly, why should we give critical constitutional importance to the economic or non-economic nature of an interstate commerce affecting clause? If chemical emanations through indirect environmental change cause identical severe commercial harm outside a state, why should it matter whether local factories or home fireplaces release them? The Constitution itself refers only to Congress's power to regulate commerce among the several states and to make laws necessary and proper to implement that power. The language says nothing about either the local nature or the economic nature of an interstate commerce affecting cause. This court has long held that only the interstate commercial effects not the local nature of the cause, are constitutionally relevant. Nothing in the Constitution's language or that of earlier cases prior to Lopez explains why the court should ignore one highly relevant characteristic of interstate commerce affecting cause, how local it is, while placing critical constitutional weight upon a different, less obviously relevant feature, how economic it is. Most important, the court's complex rules seem unlikely to help secure the very object that they seek, namely, the protection of areas of traditional state regulation from federal intrusion. The court's rules, even if broadly interpretive, are under-inclusive. The local pickpocket is no less a traditional subject of state regulation than is the local gender-motivated assault. Regardless, the court reaffirms, as it should, Congress's well-established and frequently exercised power to enact laws that satisfy a commerce-related jurisdictional prerequisite. For example, that some item relevant to the federally regulated activity has at some time crossed a state line. And in a world where most everyday products or their component parts cross interstate boundaries, Congress will frequently find it possible to redraft a statute using language that ties the regulation to the interstate movement of some relevant object, thereby regulating local criminal activity or, for that matter, family affairs. Although this possibility does not give the federal government the power to regulate everything, it means that any substantive limitation will apply randomly in terms of the interest the majority seeks to protect. How much would be gained, for example, were Congress to reenact the present law in the form of an act forbidding violence against women perpetrated at public accommodations or by those who have moved in or through the use of items that have moved in interstate commerce? Complex Commerce Clause rules creating fine distinctions that achieve only random results do little to further the important Federalist interests that called them into being. That is why modern, pre-Lopez case law rejected them. The majority, aware of these difficulties, is nonetheless concerned with what it sees as an important contrary consideration. To determine the lawfulness of statutes simply by asking whether Congress could reasonably have found that aggregated local instances significantly affect interstate commerce will allow Congress to regulate almost anything. Virtually all local activity, when instances are aggregated, can have substantial effects on employment, production, transit, or consumption. Hence, Congress could regulate any crime and perhaps marriage, divorce, and child rearing as well, obliterating the Constitution's distinction between national and local authority. This consideration, however, while serious, does not reflect a jurisprudential defect so much as it reflects a practical reality. We live in a nation knit together by 2 centuries of scientific, technological, commercial, and environmental change. Those changes, taken together, mean that virtually every kind of activity, no matter how local, genuinely can affect commerce or its conditions outside the state, at least when considered in the aggregate. And that fact makes it close to impossible for courts to develop meaningful subject matter categories that would exclude some kinds of local activities from ordinary Commerce Clause aggregation rules without, at the same time, depriving Congress of the power to regulate activities that have a genuine and important effect on interstate commerce. Since judges cannot change the world, the defect means that within the bounds of the rational, Congress, not the courts, must remain primarily responsible for striking the appropriate state-federal balance. Moreover, Congress often can better reflect state concerns for autonomy in the details of sophisticated statutory schemes than can the judiciary, which cannot easily gather the relevant facts, and which must apply more general legal rules and categories. Not surprisingly, the bulk of American law is still state law, and overwhelmingly so. I would also note that Congress, when it enacted the statute, followed procedures that helped protect the federalism values at stake. It provided adequate notice to the states of its intent to legislate in an area of traditional state regulation, and in response, attorneys general in the overwhelming majority of states, 38, supported congressional legislation, telling Congress that our experience as attorneys general strengthens our belief that the problem of violence against women is a national one, requiring federal attention, federal leadership, and federal funds. Moreover, as Justice Souter has pointed out, Congress compiled a mountain of data explicitly documenting the interstate commercial effects of gender-motivated crimes of violence. After considering alternatives, it focused the federal law upon documented deficiencies in state legal systems, and it tailored the law to prevent its use in certain areas of traditional state concern, such as divorce, alimony, or child custody. Consequently, the law before us seems to represent an instance not of state or federal conflict, but of state or federal efforts to cooperate in order to help solve a mutually acknowledged national problem. I call attention to the legislative process leading up to enactment of this statute because, as the majority recognizes, it far surpasses that which led to the enactment of the statute we considered in Lopez. And even were I to accept Lopez as an accurate statement of the law, which I do not, that distinction provides a possible basis for upholding the law here. This court, on occasion, has pointed to the importance of procedural limitations in keeping the power of Congress in check. Commentators also have suggested that the thoroughness of legislative procedures, e.g., whether Congress took a hard look, might sometimes make a determinative difference in a Commerce Clause case, say when Congress legislates in an area of traditional state regulation. Of course, any judicial insistence that Congress follow particular procedures might itself intrude upon congressional prerogatives and embody difficult definitional problems, but the intrusion, problems, and consequences all would seem less serious than those embodied in the majority's approach. I continue to agree with Justice Souter that the court's traditional rational basis approach is sufficient, but I recognize that the law in this area is unstable and that time and experience may demonstrate both the unworkability of the majority's rules and the superiority of Congress's own procedural approach, in which case the law may evolve towards a rule that, in certain difficult Commerce Clause cases, takes account of the thoroughness with which Congress has considered the federalism issue. For these reasons, as well as those set forth by Justice Souter, this statute falls well within Congress's Commerce Clause authority, and I dissent from the court's contrary conclusion. Given my conclusion on the Commerce Clause question, I need not consider Congress's authority under Section 5 of the 14th Amendment. Nonetheless, I doubt the court's reasoning rejecting that source of authority. The court points out that in United States v. Harris and the civil rights cases, the court held that Section 5 does not authorize Congress to use the 14th Amendment as a source of power to remedy the conduct of private persons. That is certainly so. The federal government's argument, however, is that Congress used Section 5 to remedy the actions of state actors, namely those states which, through discriminatory design or the discriminatory conduct of their officials, fail to provide adequate or any state remedies for women injured by gender-motivated violence, a failure that the states and Congress documented in depth. Neither Harris nor the civil rights cases considered this kind of claim. The court in Harris specifically said that it treated the federal laws in question as directed exclusively against the action of private persons, without reference to the laws of the state or their administration by her officers. The court responds directly to the relevant state actor claim by finding that the present law lacks congruence and proportionality to the state discrimination that it purports to remedy. That is because the law, unlike federal laws prohibiting literacy tests for voting, imposing voting rights requirements, or punishing state officials who intentionally discriminated in jury selection, is not directed at any state or state actor. But why can Congress not provide a remedy against private actors? Those private actors, of course, did not themselves violate the Constitution, but this court has held that Congress, at least sometimes, can enact remedial legislation that prohibits conduct which is not itself unconstitutional. The statutory remedy does not in any sense purport to determine what constitutes a constitutional violation. It intrudes little upon either states or private parties. It may lead state actors to improve their own remedial systems, primarily through example. It restricts private actors only by imposing liability for private conduct that is, in the main, already forbidden by state law. Why is the remedy disproportionate? And given the relation between remedy and violation, the creation of a federal remedy to substitute for constitutionally inadequate state remedies where is the lack of congruence? The majority adds that Congress found that the problem of inadequacy of state remedies does not exist in all states or even most states, but Congress had before it the task force reports of at least 21 states documenting constitutional violations, and it made its own findings about pervasive gender-based stereotypes hampering many state legal systems, sometimes unconstitutionally so. The record nowhere reveals a congressional finding that the problem does not exist elsewhere. Why can Congress not take the evidence before it as evidence of a national problem? This court has not previously held that Congress must document the existence of a problem in every state prior to proposing a national solution. And the deference this court gives to Congress's chosen remedy under Section 5 suggests that any such requirement would be inappropriate. Despite my doubts about the majority Section 5 reasoning, I need not and do not answer the Section 5 question, which I would leave for more thorough analysis if necessary on another occasion. Rather, in my view, the Commerce Clause provides an adequate basis for the statute before us, and I would uphold its constitutionality as the necessary and proper exercise of legislative power granted to Congress by that clause. For more audio cases, visit us at laudioforlisteners.com. Follow us on Instagram and Facebook, and subscribe to our YouTube channel.